Welcome to Business Builders. Today we're joined by Matthew Harrison of Harrison Law. Welcome, Matthew.
Hello, I'm happy to be here. Glad to help.
Today we're talking a little bit about service agreements and contracts. Quite a few of our smaller businesses may be still working on just showing up and doing the job, or handshake agreements, those sorts of things, verbal agreements. Tell us why we need to have some of these business agreements and contracts in place.
One perspective that new business owners should have is that every agreement that they do needs to be in writing. And it's for a few different reasons. Primarily, it is number one, it actually defines what you're going to do, and it's in black and white. And so that way it helps avoid any confusion that you might have with the other party. They believe something was agreed to verbally or a handshake deal, and you agree with something else. So that way, as you put it in writing, you're defining what you actually agreed to. And if the two parties, you and this other entity, can't agree on writing what is the parameters of what you're supposed to do, it kind of tells you right away that there's going to be issues with that contract and that agreement, and you need to avoid it. A lot of people just want to be informal. They want to do what's referred to back in the day as the handshake deal. Handshake deals don't help anyone involved because you're unable to define what you're actually going to do and what the relationship is. And then it becomes extremely difficult to enforce it. So if you're not getting paid, if they're doing some kind of they're not agreeing to something they agreed to verbally previously, it becomes nigh to impossible to enforce it. Then it becomes what's often referred to as that he said, she said, or whatever the terminology is, and then the court or some jury doesn't know what happened. You're kind of going by who they believe, and that becomes extremely difficult.
And I would imagine expensive too, right? Trying to get that worked out.
Yeah.
I think scope of work is probably an important aspect of that too, right? So you start getting into the job that you think is going to be one thing, but suddenly it's something else altogether. Is scope of work included in that?
Yes, I mean, essentially what a written contract is that you're putting in terms, you're defining the relationship of what you're going to do for the other party or that other party is going to do for you. And that often includes scope. Actually, it's one of the first things that are often mentioned in a written contract is what's the scope of the work, and defining what you're going to provide or the other party's going to provide, when they're going to provide it, and what happens if they're unable to provide it. And that's what you're going through scope, is those different elements to just essentially say, this is what we're agreeing to, and this is when we expect it to happen. And if it doesn't happen, what's the remedies that either party can take because it doesn't happen?
Right. So in order to get a business agreement or service contract of some type, is it better to have a boilerplate versus nothing, or should everybody go straight to an attorney and get something custom made?
Well, what I typically recommend is this, and I kind of come up from the view of that nowadays, I want people to avoid what I refer to as documents by Google, which means, unfortunately, new businesses decide that they go online, they just do a search saying, I need a contract for whatever, and they get some document, heaven knows what came from, and then they decide to use it. And there's some huge pitfalls in doing that. Number one, you don't know if it's been created properly. Number two, you don't even know if it's in compliance with the laws of the state that you're in. So is it even Arizona compliant? And sometimes you're getting templates that are 5, 10, 15 years old, 20 plus years old, that someone just slapped on the internet and didn't really take a lot of forethought to do it. So I always want to tell people to avoid it. And I've had circumstances where I've reviewed contracts, and it's the law of the state of Kansas or some other state way of Arizona. I'm going, why does this talk about Kansas in here? And they admit at that time they just found it on the internet. All of a sudden thought it was right to do, and in the end, it cost them more time and money to fix the problem now that the problem had occurred. Usually, I mean, as an attorney, I typically recommend to my business clients that it's best for an attorney to establish the template of a contract that they would utilize on a regular basis. So say if you're a service company and you provide a certain service, whether it be AC or plumbing, or you're doing some kind of work like that in the construction realm, or if you're just providing a service like you're providing VoIP or some other kind of general kind of good or service, is that with those clients, we develop a template that basically defines the big picture terms and conditions that should be in every contract. And then it's set up in such a way where then the client can fill in the names and numbers. So if they're not rushing back to a law firm every time they get a new client or customer, but basically they have this agreement in place that is Arizona compliant with the current laws, and they can then utilize, and they're just filling in the names of the individuals, the date that they would receive this by, and the price, and then you're good to go. Usually the investment in doing something like that is far greater and far more beneficial than the cost of fixing something after it's done. Usually, again, the old adage, the ounce of prevention is worth a pound of cure. That's exactly the case here, is that investing in a contract template or templates, depending on what you do, will be far more beneficial than having an attorney coming after the situation, try to fix things with the opposing side or in court. It's far more beneficial and far more cost efficient to do it that way.
Right, get it set up straight from the beginning and not have to spend the time trying to unravel it and fix it and remedy a situation. Do they have to be complicated? Do they have to be? So I've seen recently a contract that was probably 13 pages long for what seemed to be pretty straightforward service. And in fact, I didn't end up signing because I didn't even understand all of the paragraphs. So I had to have it reviewed beforehand. Does it have to be like that, or can they be pretty straightforward?
Well, I would say that straightforward is any time that it at least has the terms and conditions that are essential for a contract, and then the terms and conditions that protect you and the other parties, and depends on the type of contract you're doing and what your role or party is in this contract. For like a basic purchase sale agreement, just I'm providing a service, I'm charging $1,000 for the service, and you're gonna supply me the money for this service, then usually those contracts are only a few pages long. They're not as complex because it's a one and done. You're basically there to perform one service. It's going to be finished quickly, and then you're on to the next client and customer, and they're on to the next person that they would utilize in the future. Those can be very kind of, again, a lot more succinct. If you are in a contract that either is involving a large sum of money or a large responsibility, say for an example, if someone's a general contractor and is contracting with an owner and for a project, or is contracting the subcontractors to do work for the project. Those type of agreements or master services agreements, if it's a subcontractor, are fairly complex because the project's complex and because what they're doing is that circumstance. And so I'll see those and the larger items, and then you'll go about in that route. A lot of people get either they don't understand or they become somewhat confused when they hear the term boilerplate. and boilerplate language. Now, I say boilerplate language is good if it says what it should say, because boilerplate means it's essential elements or terms that should be in every contract, no matter what type of contract it is. So whether it be a one and done or whether it be a complex contract where you're going to be providing goods and services for an extended period of time, sometimes years, there's going to be certain language in there that's included in both those styles of contracts, and they're realistically there to protect you. And realistically, boilerplate is good because it's been established by the courts. It's good. So you don't want to have to continue to reinvent the wheel every time you have a contract. So you put in the standard terms and conditions that protect you in the circumstances in that situation.
So we start with the standard terms and then add on based on how complicated the relationship's going to be over time.
Yeah, and the
So-
time element's essential, and that will make the contract more complex if the time element is there.
So with that in mind, when should somebody come and see you? At what point in the business cycle? So like, let's say they're starting out. When do they come and see an attorney like you?
Usually with my clients, if they're just starting out and they have a concept, but they haven't really taken the steps to quote, open their doors. They're not to that point in time. Typically, those startup companies will come to me approximately 6 months in advance. That's kind of optimal because it usually takes a few months for them to figure out what they want to do and then have us do it for them. And then have it all in place. So by the time they kind of open their doors for business, it's already there. And so by that time, we've established the corporate entity, we've established the key parts of that corporate entity, we've established the basic contracts, we've helped them negotiate their first contracts, which may be, say, like a lease for a commercial space or do things like that. And so usually by the time they open the door, all those things are in place. Can we do it quicker than that? The answer is yes. I mean, we've done it in 3 months or 2 months or something like that. But what we want to avoid is what I refer to as the ready, fire, aim approach, which means a business person coming in with a great concept and does all these things ahead of time, but doesn't really think that this is what they need. And then they don't really understand what they need. And so they're going in and they're filling up forms with the Arizona Corporation Commission and other places. And they think they're doing this one item, but in fact, they're doing exactly the opposite, but they don't understand it. And then for those type of clients, the first part of our representation is fixing those past mistakes. And so we want to avoid that as much as possible. And that often happens when someone does something that's rushed, something that's spontaneous. And so we want to have them kind of sit down. And part of being a business owner is having a business plan. I mean, almost all business success people talk about the importance of a business plan, and you should have that legal element part of that business plan weeks, months before you actually open your doors.
And so let's say somebody has already opened and has been maybe working on the handshake deal. Still good to come in at some point, right? And take care of these things, start fresh.
Yeah, absolutely. I mean, I'll often see this. I'll have people come in stages or companies come in stages. And sometimes the first stage is the startup, and sometimes they'll come in right away because they have this plan in this business, or they need help with this contract, or how do I create this contract because I'm going to help these customers in this sort of business avenue, and that's fine. But then I'll have people that have kind of been on a shoestring budget and they're doing it on their own, and they're just starting their business idea and concept, and they don't really utilize an attorney right away. But they still have a good business concept. They're great workers. They become successful at that business. And that kind of leads to stage 2. And I'll have clients come in and say, hey, we started this a couple of years ago and it actually works and we're successful. But now we see problems on the horizon because I dealt with this one client or customer, or I dealt with this one contract for this vendor who's supplying me things, and I got ripped off. I got into issues. And then they kind of realize that, okay, now that we're established, we really need an attorney. And so we certainly do help them in that situation. Usually what we do is we figure out what they've done in the past and then just revise it and replace it with something that's actually works in the future, protects them legally a little bit more. I often, from those type of clients, ask for what's referred to as a wish list. What do you want to see happen? What are the terms in the contract that you've seen worked in the past? What are some things that have caused problems in the past? And then we'll cater their agreements or templates or whatever they want us to do to kind of emphasize what's worked in the past for them and their business model, and then make sure that we're covering and protecting them as much as the issues or those landmines that they've seen occur in the now or in the future.
Well, it really sounds like the key is being proactive. So whatever stage you're at, come and take care of it before there's an actual problem. And it will still cost less money than waiting until there's a problem. Is that about the key?
Yeah, the amount of investment and people sometimes are intimidated by attorneys and law firms because they think it's expensive and they think that it's an office with a bunch of books on the wall and they're not going to be able to understand what's going on. Somewhat, they're a little bit concerned. And I always tell people that us doing work ahead of time before there's a problem is far, far, far less expensive than actually dealing with the problem itself. And usually it's by a factor of 5 to 10 at a minimum, that if we're creating a template and it costs this amount of money, realistically, if there's a dispute and say you didn't fix this and you had a dispute, it's going to cost you 10 times more in fees and costs than it would have been just to have the right document and agreement in place. So it's a good investment to have for your company and your business. And also people have to realize is that it doesn't matter how good of a business person you are, you're going to have disputes because you can't control the other side of that dispute. And there's going to be individuals or companies you deal with that are not running their business properly. They're trying to cheat you, even in that kind of situation, either incompetence or inappropriate actions. And so that even if you're a great business person, it's going to happen. So you need the agreement in place to protect you. So when those people do come, you can just fall back on that agreement and say, wait a second, this is not what this says, and this is not what we agreed to. And it at least helps reduce the amount of potential exposure that you have, because you'll still have disputes no matter what. So you might as well be protected so that when that bad person comes through, you'll know how to deal with it, and it's not going to substantially derail your business because of it.
Really the key, getting the protection in place beforehand. Matthew, we really appreciate your time and the information you've given us today. Is there anything that you would like to cover that we haven't covered?
Well, I think that the main item is that, as we talked about, is being proactive, and that you really have to be proactive from the get-go. And always remember that you might have a great idea that is as an idea stage, but you really need individuals around you that can help make that idea become an actual reality that's feasible and it has long-term benefit. So part of any startup or any successful organization or business should have people that they can trust in that situation. Attorney is just one of those elements. I always talk about the importance of having someone with financial circumstances, a CPA or accountant, bookkeeper. You should have take the advice of different business coaches or other things you might be involved in. Be involved in organizations like the Chamber of Commerce, where you can talk to other individuals that are in the same position as you and are able to bounce off ideas and what's good or bad. Take advantage of those things, because you want people in your corner and be able to provide you advice that's not just they're not selling you, because a lot of times people take advice from people that just want to sell them something, but realistically you want to avoid that. as much as you can. Just have some key players in place to do that. And they'll tell you and give you an honest assessment of what your ideas either be good or bad. And often I do that with clients, is that I'll give them what I think is good and what I think is bad. And that, I give them options and analysis and they make decisions, but at least you have the information. So if you make that decision, at least they're aware of the risks involved. And that way it doesn't come back and surprise you. I often kind of smile when a potential client comes in and they're shocked and amazed that this happened. And yeah, I kind of think, well, did you read what you signed? Because it doesn't make sense. So you always want to make sure you do that. So get some people in your corner to help you. Get some people that you can give you straight advice and tell you what's good or bad. And that will help increase the odds of your success, because businesses fail, especially those first 5 years, because they're not really established properly. And then the next set of businesses fail in about the next 5 years because they've been successful and now they have problems because of success. So you just want to have some people in place to make sure you avoid those two issues that happen.
Really about heading off the problems ahead of time. I think that's great.
It's always easier to fix it, or it's always easier to prevent the problem than fixing it.
Very good. Matthew Harrison, Harrison Law, thank you so much. And we look forward to talking to you more in the future.
Okay, great. Nice to speak with you. And hopefully then again, if people need questions or issues, they can certainly contact the chamber and myself, and we can go from there.
Great.
Thank you.